In response to the statement made by the Securities and Exchange Commission (SEC) that XRP itself is a securities binomial, a cryptocurrency exchange has initiated legal action against the SEC. Binomial, which is in the business of trading cryptocurrency futures, has been in a scenario where they are unable to launch the product. This is due to the fact that the system is technically hard to implement. This not only constitutes a full-scale assault on Ripple, but it also constitutes an assault on everything else that is associated with the XRP ecosystem overall. Because of the abhorrent acts that they have taken, the attorneys for the Securities and Exchange Commission have turned the issue into a living nightmare for everyone who is involved in it. In the meantime, they are making life a living hell for everyone involved for the same reason that they are making life a living nightmare for everyone involved. It was in August of the previous year that the Securities and Exchange Commission wrote a letter to Judge Torsen regarding the xrp+ripple case. In the letter, they stated that they would not be challenging the legal status of XRP by adopting the embodiment theory, which asserts that everything is embodied, that XRP as a security is something that they have been asserting. During the course of the SEC Ripple litigation, Binomial, on the other side, has been contending that XRP is a security, which is an assertion that is totally absurd. A lawsuit that was filed by Binomial on October 10th and submitted to a federal court in Illinois. The lawsuit was filed in Illinois. As a consequence of this, Binomial is subjected to an additional regulatory burden, which, according to the exchange, is an unacceptable duplication of efforts. In August, Binomial made a self-certification application to the Commodity Futures Trading Commission in order to introduce XRP futures contracts on its exchange prior to launching the product. The exchange issued a statement stating that it had been contacted by the Securities and Exchange Commission, which declared that XRP futures will be considered securities. Additionally, the Securities and Exchange Commission (SEC) required that Binomial register as a securities exchange. It is not even close to being sane to express this. Binomial has declared that it is unable to meet the legal requirements necessary to list XRP futures. This is due to the fact that Ripple Labs, the business that is responsible for issuing XRP futures, is obliged to register it as a security. Binomial has been effectively banned from issuing XRP futures as a result of the SEC decision. Due to the fact that Ripple Labs did not in fact develop XRP, this is the case. Prior to the founding of Ripple Labs, it has already been in existence the entire time. In response to the claims made by Binomial, the Securities and Exchange Commission has pointed out the implied nature of the SEC's operations and the factual irregularity that was present in their filings. There are others who believe that the actions taken by the Securities and Exchange Commission do not engage in true engagement, do not seek the truth, and do not protect investors. In a nutshell, the actions taken by the Securities and Exchange Commission (SEC) have caused a significant disruption within which is currently engaged in legal battles and may be subject to legal complications in the future. In order to address these concerns and ensure that the legal underpinning for XRP is maintained in its totality and continues to be applicable, the Securities and Exchange Commission (SEC) needs to take proactive measures. Cointelegraph reports that Binomial, the company that is currently suing the Securities and Exchange Commission, has asserted that Ripple Labs is the entity that is responsible for the issuance of XRP. Binomial has been putting up this argument for a number of years, claiming that XRP was created by a Ripple. This is a concept that can be easily debunked when it is examined in further detail. On the other hand, Binomial did not provide themselves with that argument. In addition, the 7th paragraph of the complaint that Binomial submitted to the SEC the day before was rejected. There is no registration for the underlying security, which is XRP. Additionally, Binomial is not the company that is responsible for issuing XRP, due to the fact that the Securities and Exchange Commission is aware of this particular information. The organization does not have the authority to register XRP, despite the fact that it would desire to do so. Binomial has been effectively banned from offering XRP futures as a result of the Securities and Exchange Commission intervention. And on the other side, Ripple was unable to accomplish this goal because they do not have ownership over the asset and it is not theirs to begin with. Brad Garlinghouse has expressed his concern on this matter, and he has stated that Binomial would have been furious and yelled about it if they had sought to register XRP. He has also stated that he is concerned about this matter. Binomial, on the other hand, did not comply with this provision. As of right now, the Securities and Exchange Commission is of the opinion that XRP may be operating beyond the law, despite the fact that a court has decided that it is not a security team. Ripple will be keeping a close eye on the situation and examining their alternative in order to guarantee that the Securities and Exchange Commission (SEC) is held accountable. Attorney Bill Morgan, who is also a member of the XRP community, is the one who penned the following, and he also provided a screen capture of the case. He had the intention of attracting the attention of Binomials to the 3 segments that were to follow. First, the allegations that Binomials has made against the Securities and Exchange Commission, which can be found in verses 34 to 36, by the provision of documents of its summary litigation filed with the SEC by Binomials. The Securities and Exchange Commission (CC) offered evidence in support of their claim that XRP ought to be classified as a security. 2. In the case brought by the Securities and Exchange Commission, the Securities and Exchange Commission gave Binomial copies of its summary judgment brief. The purpose of this discussion was to determine which transactions involving XRP constituted sales of an investment contract and to reach a conclusion about the dispute. Despite the fact that the Securities and Exchange Commission SEC sent Bitnomial the ruling of the second SAC case, they failed to mention that XRP itself was not considered to be a securities. There have been allegations that Bitnomial has been dishonest and intentionally dishonest about the events that transpired as a consequence of the steps that they took regarding the problem. Attorney Bill Morgan, who is also a member of the XRP community, is the one who penned the following, and he also provided a screen capture of the case. By acting in this manner, Bitnomial has raised concerns over the ability of the Securities and Exchange Commission to continue to operate independently of the law and to receive accountability for its actions. In the event that the matter is brought before a judge, he believes that the judge will most likely be able to see through the lies and hold Bitnomial accountable for the actions it has taken. To provide a brief summary, the case that Bitnomial has lodged against the Securities and Exchange Commission is both ridiculous and insanity. The Securities and Exchange Commission has not only been accused of lying and being dishonest, but it has also failed to acknowledge the fact that XRP is not a security even though it has been accused of both of these things. The necessity of accountability and transparency in the Bitcoin industry should be brought to light. As a result of the Securities and Exchange Commission's advocacy for the sale of XRP futures, the agency has been accused of participating in unethical government actions and of attempting to cause financial harm to individuals and businesses, rather than coming to the conclusion that XRP was a security in some instances but not in others, as was previously stated. The position made by the Department of Securities and Exchange Commission that all of the XRP sales that were at issue were of an investment contract and, as a consequence, sales of a security was rejected by the district court. It has been suggested by legal experts that the language that is being used by the Securities and Exchange Commission is reckless, and that there is no possibility for the SEC to get back on its feet under the existing structure. This has resulted in a disagreement between many legal experts. Fred Ripley, an additional attorney, has expressed his concerns regarding the actions taken by the Securities and Exchange Commission, as well as the likelihood of Jury 10. The lead attorney in the SEC Ripple case, Ray Rowe, is being disbarred from the association. If the individual's complaint is permitted to progress, the individual believes that it could lead to the individual's disbarment from the legal profession. On the other hand, there have been complaints filed against him and other attorneys, such as his Bill Morgan, who were skeptical as to why Bitnomial XRP futures did not appear to be active after the important announcement that was made in August. These complaints have been placed against him. The Securities and Exchange Commission has been accused of asserting that if Bitnomial were to list XRP futures, it would be in violation of federal securities regulations. This is due to the fact that XRP futures are deemed to be security futures. The court and the SEC have both come to the conclusion that XRP is not an investment contract. The SEC has not been able to provide any evidence to contradict this conclusion. When it comes to dealing with parties that are attempting to list a futures contract, the Securities and Exchange Commission has reached a low point since they have taken a position that is in disagreement with what they have declared to the court in another case about the underlying asset. This has caused the SEC to reach a point of no return. It has been alleged that the Securities and Exchange Commission has violated federal securities laws, and Bitnomial has initiated legal proceedings against the SEC in response to this accusation. According to their argument, the Securities and Exchange Commission is not participating in any illegal behavior, and they believe that they will not be successful in their case if the lawsuit is permitted to proceed. A conclusion has been reached that the actions taken by the Securities and Exchange Commission SEC are disheartening and should be avoided till the next time. In a nutshell, the actions taken by the Securities and Exchange Commission SEC in the Ripple case have given rise to concerns regarding the potential for bribery and other forms of misconduct inside the Bitcoin industry. By addressing these concerns and ensuring that the Securities and Exchange Commission is held accountable for its actions, which have been criticized for their actions, the CCC must ensure that it is held accountable for its operations.